Oyez, oyez, oyez. The Supreme Court of the United States is now in session. Chief Justice Bybee and Justices Lohier and Azraq are presiding. All those having business before this honorable court are admonished to draw near. God save the United States and this honorable court.
Please be seated.
The first case before the court today is United States of America versus Paul Rutherford.
We are very pleased to be with you this afternoon, and we will proceed with the only case on the docket, which is the case of United States of America versus Rutherford. Are the petitioners ready? Are the respondents ready? All right. Counsel, have you decided how to divide time?
Yes, sir.
Okay. Then counsel for petitioner may proceed when ready.
Thank you, Chief Justice, and may it please the court. I'm John Bullock, and together with my co-counsel, Lydia Bolander-Reback, I represent the petitioner, the United States of America. At this time, I would like to reserve 3 minutes for rebuttal.
You may do so.
Your Honors, this case presents 3 issues.
Counsel, you may have to pull the microphone up just a little bit, make sure that you can be heard.
Is that better, Your Honor?
That is better. Thank you.
Your Honors, this case presents 3 issues for the court to decide. I will discuss the first 2 issues involving the good faith exception to the exclusionary rule and Rule 803.3, and my co-counsel will discuss the remaining issue involving the confrontation clause. Your Honors, the 14th Circuit erred by excluding the evidence obtained through Governor Rutherford's, the search of Governor Rutherford's email and the evidence of Victor Smith's statements of his then existing state of mind for 2 reasons. First, the good faith exception covers the law enforcement's conduct because officers from the FBI were acting objectively reasonably and relying on a facially valid search warrant issued by a neutral magistrate. Second, with respect to the 803.3 issue, Victor Smith's statements of his then existing intent fall within the plain language of that rule. Your Honors, in this case, a state police officer of the Borum State Police obtained evidence that was outside of the scope of his warrant and then provided that evidence to the FBI. FBI agent Fonseca disclosed the nature of that evidence and how it was obtained to a neutral magistrate who, viewing the totality of the evidence, decided to issue a search warrant for Governor Rutherford's computer. FBI agents then executed that search warrant and complied with the scope of that search warrant, and those agents were acting objectively reasonably when they did so.
Counsel, I have read the record and I have seen the affidavit that was submitted to the magistrate judge. Are we confident that the magistrate judge understood that Officer Scott's actions were well outside of the scope of the warrant that he possessed?
Your Honor, Agent Fonseca did disclose to the magistrate that Officer Scott went beyond the scope of his warrant and in obtaining that evidence, and it would be incumbent upon the magistrate judge to have reviewed the totality of the affidavit in making her determination in this case. And we feel quite confident that she did so and did not abandon her judicial role in issuing that search warrant.
And do you concede, for purposes of this appeal to us, that the initially obtained evidence was obtained in violation of law?
Yes, Your Honor, we do. The initially obtained evidence consisted of both subject line and addressing information from Governor Rutherford's emails. Officer Scott was initially authorized by his warrant to be searching emails related to a corruption investigation up until June 1st, 2014. However, he went beyond the scope of that warrant when he looked to October 10th. He saw some emails from Pestex Corporation to the respondent, and in so doing, he believed that he was allowed to do that because he believed this information to be analogous to the information he could obtain with a PIN register.
And that was wrong.
Yes, Your Honor,
You're conceding that subject line is content?
Your Honor, as attorneys with the benefit of hindsight, we do concede that the subject line information does appear to be content in this case. However, we contend that Officer Scott was acting sufficiently close to the line of validity based on this court's previous precedents that he may not have been quite aware that that was content information. And the circumstances of that subject line information being next to the addressing information and the date information may have reasonably led Officer Scott to believe that that content information was actually...
But you've already conceded that it was clearly illegal, in retrospect.
Your Honor, we don't concede that it's clearly illegal. It does seem to have been a violation, well, in the sense that he should have been able to obtain a court order pursuant to 18 U.S.C. sections 31, 21 through 27 in order to obtain that addressing information. That was an illegality. However, that's not a constitutional violation. But viewing that subject line information...
Is 18 U.S.C. binding on state officers?
Yes, Your Honor, I believe it is. And in obtaining that information, he did so without a court order, and that in and of itself was an illegal viewing of that information. However, there's also the issue of the subject line information, which is the protected information under the Fourth Amendment. And viewing that information, we do concede, constituted a search within the meaning of the Fourth Amendment. However, it's important to note that when Officer Scott went and looked into this information, he did not do so under the direction of the FBI.
But he was aware that there was an FBI investigation, correct?
Your Honor, he was aware that the FBI agents were questioning Governor Rutherford to determine whether or not he had any information regarding the death of his aide, Victor Smith.
And he also understood at a certain point, if I've read the record correctly, but you can correct me if I'm wrong, that the information that he obtained illegally might be of interest to the FBI. Is that correct?
Yes, Your Honor.
And so he provided that information to the FBI.
Yes, Your Honor, he did. However, in this case, exclusion of this evidence would be punishing the FBI for state law enforcement's conduct.
Couldn't the state have prosecuted something against Mr. Rutherford for his obstruction of justice here? Something parallel to the federal prosecution?
Potentially, Your Honor, they could have.
And if so, we probably wouldn't be here on this argument, would we? No, in other words, the only reason that you're here is because you've got a good faith claim because the information was passed off to the FBI, which wasn't culpable here. But isn't the state then just sanitizing its error by handing it off to the FBI?
Your Honor, the state's error was outside of the scope of any investigation being conducted by them, and therefore they weren't obtaining that evidence for any particular purpose with respect to their own investigation, and they provided that to the FBI. At this point, the FBI...
But it could have been for a state prosecution, right? I mean, you could have developed evidence that would have provided a case against the governor.
Potentially, Your Honor, yes. And in that case, it would be quite self-serving for Officer Scott to have gone beyond the scope of the warrant and obtained this information and then sought to use that information. However, viewing this evidence, if a magistrate had determined that a search warrant should still issue, that would be something that the magistrate could do within her discretion as a judicial officer. However, those aren't the facts of the case before us. Here we have two separate law enforcement agencies that are not acting in parallel with respect to this investigation. And upon receiving this information, which the FBI did not solicit in any way, shape, or form, Agent Fonseca did the only thing that she could do with that information and disclosed the nature of how it was obtained.
How do we write then an opinion that doesn't encourage state officers to act illegally in connection with a warrant and conduct a warrantless search, for example, and then use that illegal evidence to help their federal colleagues? That is, how do we write something that doesn't subvert this idea that state actors should be very careful in conducting a search pursuant to a warrant?
Or it invites law enforcement to create just this situation and then argue for a good faith exception.
Your Honor, we urge the court to adopt the standard applied by the Fifth, Sixth, and Eighth Circuits that when an officer is acting sufficiently close to the line of validity with respect to the constitutionality of a search, that information can still be allowed if it's disclosed to a magistrate and the magistrate determines that a warrant should still issue. Your Honor, in McLean, the U.S. Court of Appeals for the Sixth Circuit held that officers were acting reasonably close to that line of validity when the initial officer believed that perhaps there may be a burglary in process, but did not actually have probable cause to do so, entered a house and found some evidence of a marijuana grow operation, and then turned that evidence over to other police officers who began surveillance of different houses and then presented all of the totality of their information to a magistrate who issued a warrant for them to conduct searches of these properties where they had found marijuana grow operations. And because that initial officer was acting sufficiently close to the line of validity with respect to his initial search of the premises, believing that he was allowed to enter...
How do we assess what's close to the line of validity?
Your Honor, it would involve an inquiry into the existing precedent and the flagrancy of the constitutional violation in the case. And particularly, the touchstone of the exclusionary rule is the deterrent value to law enforcement. And in determining whether deterrence will be achieved, we have to inquire as to law enforcement's culpability when they act. Therefore,
But you're asking us to focus on the culpability of the FBI agents. My concern is the culpability of the state officers who then have some motive to help a federal investigation.
Your Honor, if the state police officers were acting in a culpable manner in seeking to circumvent the protections of the Fourth Amendment, to provide that information to their federal counterparts, to provide, to use in a subsequent investigation, and they were acting culpably, if they were acting intentionally, recklessly, or grossly negligently, as this court noted in Davis, then they would be acting culpably. If they had some knowledge of the law and they decided to go ahead anyway, despite the fact that there was this risk, then that would be...
Right, but what we've done is we have sort of swapped a state murder charge for a federal obstruction of justice charge, right, by murdering the witness. So we sort of cleansed the record by handing this off from the state off to the feds. If we were here on the state murder charge, you would have a real problem with what Officer Scott did.
Your Honor, actually, in that scenario, Officer Scott wouldn't have been deterred because he did not believe that he did not have any idea that he was acting outside of the scope of the law. He knew that he was acting outside of the scope of the
Sure, but the next time Officer Scott conducts a computer investigation, he would be very careful, wouldn't he, if he had let somebody off of a murder charge because of his malfeasance?
Your Honor, in hindsight, Officer Scott would, of course, know that this search did pose constitutional issues, and this court's opinion, based upon the case being heard today, will be something that they can use going forth, that officers can use in guiding them as to whether or not they are acting within the bounds of the Fourth Amendment. Your Honors, with the time I have left, I would like to transition into a discussion of Rule 8033 and Victor Smith's statements of his then existing intent. Your Honor, Victor Smith told his fiancée, Anita Flores, that he intended to have dinner with Governor Rutherford on the night that he was murdered. The plain language of Rule 8033 allows this statement to come in. 8033 excludes from the rule against hearsay a declarant's statement of his then existing intent, which includes a motive or plan. It's clear that Victor Smith's plan was to go that evening to Governor Rutherford's apartment and have dinner with him at that apartment, and the state seeks to introduce that evidence. However, the 14th Circuit erroneously excluded it, recognizing that this would fall within the plain language of Rule 8033, but in order to guarantee reliability, additional reliability, in addition to that contemplated by the drafters of the rule, the 14th Circuit imposed a corroborating evidence requirement, which is found nowhere in the language of that rule.
So, counsel, on below, was the government prepared to argue that Smith intended to have dinner, and that's why they wanted to admit the fiancé statement? Or were they arguing that Smith, in fact, did have dinner with Rutherford?
Below, Your Honor, and here today, we seek to introduce that piece of evidence to show that Smith did act in accordance with his plan and did indeed go have dinner with Governor Rutherford.
How could that statement possibly support the conclusion?
Your Honor, this court in Mutual Life Insurance Company versus Hillman allowed the exact type of evidence to come in when they used letters.
Well, it might be one thing, counsel, to admit the evidence, to show that Smith intended to have dinner, and then it may be used for, to argue whatever inferences you can draw from that. But how could we possibly prove from that Smith actually had dinner with Rutherford? He might have had a flat tire on the way. If I say to my wife, I'm going to the store, that isn't proof that I actually got to the store, is it?
No, Your Honor. However, that would go more to weight than to admissibility, and the trier of fact would be well situated to hear that evidence and then determine what credibility to attach to the evidence. This court did allow in Hillman for a declarant's statements of intent to be used to show the subsequent conduct of a third party.
Does the government have anything else to show that Smith was in the area of Rutherford's home or apartment or the restaurant where they intended to meet, or that somebody saw them together, or that he arrived at the restaurant?
No, Your Honor, they do not. And that is another reason why this court should rebuke that corroborating evidence requirement. It's nowhere in the plain language of the rule. And other
Would you agree that there, I'm sorry, go ahead.
No, isn't reliability kind of at the bottom of all of rules of evidence and a court's consideration of whether to admit something? And how can this evidence be considered reliable when all we have is Smith's stated plan of I'm going to go have dinner?
Your Honor, that rule from the excluding these types of statements from the rule against hearsay is that when someone says that they're going to do something, when they haven't, when it's a statement of their then existing state of mind, their then existing intent, they typically don't have the time to premeditate and think of these things in such a way that they would be trying to that these statements would be more unreliable.
No, but that's the point. It's a statement of his intended state of mind, of Smith's intended state of mind. It doesn't support that he actually did it. And I think that's what my colleague is addressing. I mean, it's a valuable piece of circumstantial evidence of Smith's intention, but I think it's a great leap to then say, and therefore they had dinner.
Your Honor, I see my time has elapsed. May I briefly answer your question?
Yes.
Your Honor, it is true that we are attempting to use this evidence to show that Governor Rutherford was indeed with Victor Smith on the night in question. And it seems that they did have a plan together to do this, and
So if I say I plan to marry her, that has some evidentiary value and it's reliable, even though I've never spoken to her.
yes, Your Honor, that does still have some evidentiary value.
Wow.
Granted, it would be up to,
But a jury, a reasonable jury, could find that he married her because he said he was going to?
Your Honor, in the case of something that as serious as a marriage, there would be corroborating evidence. There would be other things, and it wouldn't be necessary
Sure,
to.
but if I say I'm going to have dinner tonight at Kentucky Fried Chicken, I may have been waylaid. I might have seen a sign for El Pollo Loco and decided to be deterred.
Yes, Your Honor, and of course, introducing these statements, we do run the risk that may occur, but the fact of the matter is that this was contemplated by the advisory committee and Congress when they passed this law, and they determined that this type of evidence was sufficiently reliable. And for those reasons, we respectfully ask this court to reverse the decision below. Thank you.
Thank you, counsel.
Thank you.
Thank you, Chief Justice, and may it please the court. My name is Lydia Bolander-Reback, and I represent the petitioner. Your Honors, no one in this courtroom disputes the importance of the defendant's constitutional rights, but those rights are not implicated by the admission of non-testimonial statements by an expert witness who the defendant will have the opportunity to cross-examine. In holding otherwise, the 14th Circuit erred for 3 critical reasons. First, Dr. Chin's testimony meets the requirements of Federal Rule of Evidence 703 and should have been held admissible. Second, Dr. Chin's testimony is based on the non-testimonial statements of Dr. Fleischer's autopsy report. Because those statements are neither offered for their truth nor testimonial in nature, they do not invoke the defendant's Confrontation Clause rights. And finally, Your Honors, the decision of the 14th Circuit sets a dangerous precedent that will harm this defendant and both defendants and cold case victims moving forward. Your Honors, Dr. Chin's testimony meets all the requirements of Federal Rule of Evidence 703 and represents the exact situation contemplated by that rule. Dr. Chin has taken not only the objective evidence contained within Dr. Fleischer's autopsy report, but also conducted independent research in order to offer an informed opinion.
What is the difference between an autopsy report for our purposes and, say, a DA chemist's report that says, for example, this thing that we found or that you found contained 1 or more kilograms of heroin?
I'm sorry, I'm not sure I understand.
So
So
what
a
is the
forensic
difference between a
report,
DA chemist report and an autopsy report
Well,
for purposes of this argument?
for purposes of this argument, Your Honor, the circumstances of the particular DA report might bear on the determination of whether it was testimonial in nature or not. But with regard to this particular autopsy report, it is not testimonial under any of the tests that have been articulated by this court in the past. Beginning with this court's decision in Crawford, there have been a number of different articulations of the inquiry as to whether a particular statement is testimonial in nature. In Crawford, this court explained that a statement that is offered not only for its truth, but is also sufficiently formal, could constitute a testimonial statement or a solemn or formal statement. And then in both Melendez-Diaz and Bullcoming, this court articulated slightly different, but essentially formulations that look to what the purpose of the statement was and whether it was made in an attempt to further a law enforcement investigation, and furthermore, whether that was its primary or sole purpose. Then.
So what do you consider the significance of the fact that here we are and this is being sought to be used in a criminal trial?
Well, Your Honor, the significance of that context is that it bears on whether, in fact, Dr. Fleischer's autopsy report is a testimonial statement insofar as this court considers the Bullcoming or Melendez-Diaz tests to control that analysis.
And how much does subjectivity come into play?
Well, it comes into, if I'm understanding your question, and the subjectivity is this possible subjectivity contained within the autopsy report, then that would come into play in the context of which elements of the autopsy report the government was seeking to introduce. Here, the government does not seek to introduce the autopsy report in its entirety. Rather, it seeks to offer, as was articulated before the district court, the government is offering only the objective data contained within the autopsy report and not Dr. Fleischer's conclusions about that data. Dr. Chin has...
So no value, the things that they're offering don't require a value judgment on behalf of Chin or
That's right.
previously by Fleischer?
So, correct, Your Honor. So Dr. Chin was able to, taking from Dr. Fleischer's autopsy report, Dr. Chin was able to conclude and would offer at trial her own opinion that the chemical homidine was the source of Victor Smith's death. And while Dr. Fleischer, for example, described Pest X generally as the cause of death, Dr. Chin was able to look at the conclusions, or not the conclusions, excuse me, look at the descriptive factors that were offered in the autopsy report and confirm based on that objective data that homidine was the likely cause of death. And she would be cross-examined about her rationale, about her methodology, and about the additional research that led to her development of that opinion at trial. And Your Honors, returning to my point here, that Rule 703 contemplates this exact situation. If an expert witness like Dr. Chin is made aware of out-of-court statements, their admissibility independent of that expert is not relevant. She can testify to those results even if they themselves are not admissible. So by relying on these objective statements in Dr. Fleischer's report, Dr. Chin is qualified to testify. She's relied reasonably on those statements and can testify under the boundaries of that rule. Furthermore, Your Honors, this statement is not being offered for its truth, nor is it testimonial in nature. With this case, the court has the opportunity to affirm that neither the targeted individual test nor the solemn or formal test is sufficient to determine what is a testimonial statement. Here, we can affirm firmly that the determination of what causes a statement to be testimonial is whether its sole purpose was for use in a law enforcement investigation. And here, Dr. Fleischer's report does not meet that requirement.
He refers to, this is evidence of homicide. I mean, you can say that you're going to redact the summary, but he specifically refers at the end of his report to the fact that his conclusion is it's evidence of a homicide or suicide. Why isn't that an indication, at least, that he understood that this might be used in connection with a murder trial?
Well, Your Honor, again, the particular formulation of whether his wording rises to the level of a testimonial statement is a significant concern for this court. And by failing to determine whether it was a homicide or a suicide, Dr. Fleischer's report left that highly inconclusive, and thus it's unclear whether that report would likely be used later at trial.
Why shouldn't the lack of clarity inure to the benefit of the person claiming the Sixth Amendment protection?
Your Honor, because the greater circumstances surrounding a decision in this case holding that autopsy reports like this one require the original preparer to testify, that's simply a line in the sand that this court should not draw. This court, by holding that this autopsy report is testimonial, would call into question whether any future forensic report that makes any possible outcome determination, whether any of those reports are also testimonial. And as this court has held a number of times, that's a bridge too far, frankly. And this would create a statute
Where have we held that?
Well, Your Honor, while this court held in in Williams that the plurality of the court required that the report actually target a specific individual and not merely relate data in order.
When you say the plurality, so I look at Justice Breyer, who was part of the 5. Did he say that?
To my memory, no, Your Honor.
Okay. So you've got 4 people, maybe 3, who say what you claim the court said. But as I understand it, you correct me if I'm wrong, Justice Breyer said, this is an unanswered question. Is that correct?
Yes, Your Honor. So returning to clarify what I said before, the question is whether the report is not only possibly for use in a future law enforcement investigation, but whether it was created solely for that purpose or whether its primary purpose was for future use by law enforcement. And so the level of ambiguity that was created throughout this process means that that could have served any number of functions. And furthermore, it was prepared pursuant to Dr. Fleischer's statutory obligations to document the manner of death, not to target an individual, not inherently to serve a law enforcement function. And though conceitedly it was sufficiently formal, it does not meet the more recent tests that have been articulated by this court. So for those reasons, Your Honor, it's a stretch to say that Dr. Fleischer knew that this would be serving the sole purpose of being used in a law enforcement investigation.
Is it your position that the admission of a forensic report could never violate the Confrontation Clause?
No, Your Honor. For example, a forensic report that there are situations in which a forensic report and even an autopsy that was prepared under different circumstances could invoke the defendant's confrontation right. I'm thinking primarily of the case U.S. v. Ignaziak, which was a circuit case where the statutory scheme embedded the original autopsy preparer in the Office of the Medical Examiner more closely within the law enforcement agencies that it supported and had additional statutory requirements for when the autopsies must be performed. In a situation like that, where it's blatantly obvious that the reports will be consulted by law enforcement, where the Office of the Medical Examiner is functionally embedded within law enforcement, those reports certainly are much more likely to be testimonial than situations like this, where it's much more attenuated the connection between the actual autopsy as it was being prepared, as those essentially statements were being made, is much more attenuated here than it would be in a situation like that. So there are certainly not only forensic reports, but also autopsy reports specifically that could be testimonial.
In this case, when the coroner started the autopsy, he didn't know, Dr. Fleischer didn't know whether he was dealing with a murder or whether he was dealing with something else. We simply had a suspicious death, one that was
Yes.
not expected. What happens when the body is brought to the coroner's office for autopsy and it is apparent that there has been some kind of foul play? That is, it's obvious to everyone that somebody's been shot multiple times. And yet there's still a possibility that somebody didn't die from that. I've watched too many TV shows, that somebody was strangled before they were shot, or somebody had been poisoned before they were shot, or something else. Doesn't the coroner at that point know that the report is going to be used to target somebody and that there may be evidence that will be useful against somebody? And does that now shift it out of the category that you're talking about?
Well, Your Honor, I think that is, it's much more likely that that scenario would rise to the level of being a testimonial statement.
But the coroner still, in that case, would still be acting pursuant to a statutory
Yes, Your Honor.
charge, and there's still sort of a neutral.
Yes, Your Honor. And I think the distinguishing factor there is how much emphasis this court places on whether it is the sole purpose of the report to aid a law enforcement investigation or whether its primary purpose is to aid a law enforcement investigation. And if it is the sole purpose of that report, then even in the scenario that you articulated, that coroner is still performing his report. There's multiple purposes happening there. And so this case is different from that because there is not such an integral relationship between law enforcement and between Dr. Fleischer. And even as he finished his report, he was not clear on whether this was even a homicide or a suicide. And so the level of connection between law enforcement and Dr. Fleischer speaks highly to the fact that this is not a testimonial statement. Furthermore, Your Honors, the decision of the 14th Circuit is against the best interest of not only this defendant, but of future defendants. By holding that this is a if this court should hold that this is a testimonial statement, as the 14th Circuit did, that would functionally limit the state's ability to prosecute any cases that depend upon autopsy reports. Requiring the original preparer to testify is an untenable burden, and for these reasons, we ask you to reverse the decision.
How is that contrary to the interests of future defendants?
Your Honor, I see my time has expired. May I answer your question?
Of course, you may answer the question.
Okay. Your Honor, that's contrary to the interest of future defendants in the sense that by requiring the original autopsy preparer to testify at trial, or excuse me, I did misspeak. It's contrary to the interest of future victims of crime, not to the interest of future defendants. I apologize. Thank you.
Counsel. We will hear from the respondents.
Good afternoon, Mr. Chief Justice, and may it please the Court. Jonathan Claren, along with my co-counsel Jessica DeBeery, on behalf of Respondent Paul Rutherford. I will be presenting to the Court on the Fourth Amendment issue, and Ms. DeBeery will be presenting on the hearsay issues. Your Honors, deliberate and reckless police misconduct should not be able to establish probable cause. Accordingly, the 14th Circuit Court of Appeals correctly affirmed the suppression of the digital evidence below for two reasons. First, this court's narrow exception announced in United States v. Leon does not apply to predicate law enforcement misconduct. And second, should this court determine to broaden the scope of Leon, the law enforcement conduct in this case does not necessitate application of the exception. For these reasons, we ask that you affirm. I'd like to first address the conduct suggested by Petitioner of the FBI, which should not be viewed by this court through any lens of reasonableness, but rather through the good faith lens, which this court in Davis v. United States defined as manifested good faith through law enforcement actors that do not demonstrate deliberate, reckless, or otherwise grossly negligent conduct. Here, upon receipt of a clear Fourth Amendment violation, that is the information received from Officer Scott, the FBI proceeded to apply for a warrant to a neutral magistrate or judge in an attempt to, as Justice Lawyer noted earlier, cleanse the underlying taint. The FBI should have known, and we should expect all law enforcement actors demonstrating good faith pursuant to Leon, not to expect unconstitutional...
So, Mr. Claren, here's my question. Is there anything that the federal government can do at any point after a prior violation that has tainted the original search? Is there anything that it can do to cleanse that taint in order to, in connection with a totally separate investigation of a murder, pursue its investigation and seize evidence?
Yes, Your Honor. The FBI is already afforded, as an investigatory body, many powers which they can investigate, including warrant and subpoena powers during the course of their murder investigation. The FBI should not have relied on this untenable, unconstitutional information. Instead, they should have continued the course of their investigation and then approached a neutral magistrate or judge upon a finding of probable cause rooted in constitutionally obtained evidence. The FBI, and the record is clear on this, had every opportunity to continue their investigation. It was Officer Scott's deliberate and subjective determination that led him to overstep the bounds of his clear and concise warrant in
So what is it that the FBI should have done here specifically? He provides, Officer Scott provides this information. It's unsolicited, as I understand it. Should they have not disclosed it to the magistrate judge? Should they have disclosed it in some different way? What is it that you propose that the FBI should have done?
I apologize, sir. To be clear here, the FBI not disclosing this information or otherwise sitting on it is in no way malfeasance by law enforcement. Again, they should have continued the course of their investigation because at the point at which Officer Scott encountered this information, after having one single conversation with an FBI agent during the course of his state corruption investigation, he made the subjective determination to scroll through emails that were 127 days outside of the scope of his unambiguous state warrant.
So were you expecting the FBI just to turn a blind eye to what they heard from Officer Scott?
No, Your Honor, but if anything, the FBI then had a pathway which they could continue to pursue their investigation.
What should they have done?
They could have continued to conduct interviews with all witnesses who would have been relevant, and if truly they established probable cause, as they seemingly believe they did.
Could they have just sent an inquiry over to the Pest X Corporation and say, anybody sent materials out to anybody named Rutherford recently?
No, Your Honor, but based on the affidavit that the FBI submitted on pages 2 to 8, there were other instances of probable cause that may have allowed them to pursue a warrant not exercised in the broad scope of electronic documents. And then that evidence may have eventually led them to Respondent's computer.
But then wouldn't we be sitting here arguing about fruit of the poisonous tree? I mean, you know, it's like the cat out of the bag. And what's the significance of the fact that this was all fully disclosed to the magistrate judge who reviewed the affidavit?
Two issues to address your concerns, Your Honor. First, myself, Your Honors, judicial actors generally are humans. And this court noted in Malley v. Brigg that under docket pressure, it's possible that magistrate judges may make human error. And so we expect that law enforcement actors, especially those demonstrating good faith, may not bring unconstitutional evidence by which they expect to obtain a valid warrant. Simply because the FBI here played hot potato with this unconstitutionally obtained evidence shouldn't permit this court to greenlight law enforcement actors generally to, as Your Honor Justice Azraq noted earlier, collude with state and federal actors, which this court expressly overturned the silver platter doctrine in Elkins versus United States. But to that
What do you
end,
mean play hot potato with it? What are you talking about?
well, here, Your Honor, they obtained from Officer
Right,
Scott.
but they fully disclosed it to the magistrate judge. There's
But
no
that-
question that he obtained it illegally. It was fully disclosed.
Yes, Your Honor, but that doesn't solve or sanitize the underlying taint of that evidence. Your Honor mentioned the fruit of the poisonous tree, which is exactly what this court, through its judicially created remedy of the exclusionary rule, intended to combat when it announced the suppression of evidence as the only deterrent effect for future Fourth Amendment violations. Here, the FBI should have been expected to know that they cannot rely on unconstitutionally obtained evidence to pursue a valid warrant. That is not an unreasonable restraint on investigatory bodies, especially since.
Counsel, we ordinarily think of the exclusionary rule as sort of a disciplining function by the courts on the executive branch. How do we translate that in this case when the best we can do is bar critical evidence from a federal prosecution that will discipline a state officer? Now, in other words, how does Officer Scott feel disciplined by what a federal court does for the FBI's prosecution? This isn't his prosecution. It's not his jurisdiction. They're not his laws being enforced. Why does Officer Scott care?
First, Your Honor, the FBI would be incentivized by the suppression of this evidence to ensure, and by its very nature to note, the FBI will obtain evidence from all sorts of agencies. It is a special investigatory body. They will be incentivized to ensure that in the future, affiants include only constitutionally valid information to establish probable cause.
Well, that would discipline the FBI in their use of informants. But how does it get to the root of the problem, which is that Officer Scott has committed a Fourth Amendment violation? How does Officer Scott get disciplined out of our excluding evidence in this case?
To be clear, Your Honor, and this court has noted time and again, most recently in Herring versus United States, the primary purpose of the exclusionary rule is to deter future Fourth Amendment violations of all law enforcement actors. So while you're correct, Officer Scott had no affiliation with the FBI, he made his own subjective determination, all law enforcement bodies, state, federal, or otherwise, will be incentivized to ensure when executing clear and unambiguous warrants, they comply with, at the very least, statutory and warrant guidelines.
Is it also your position then that it should have been clear based on prior case law to the FBI that they could not rely on evidence procured illegally by a state officer and disclose that evidence in connection with trying to get a search warrant at the federal level? Is that,
Not
is the
quite,
law
Your-
clear on that?
No, Your Honor. This was a case of first impression in the 14th
So if
Circuit.
it's a case of first impression for us, and presumably then it's unclear to an FBI agent that they are doing anything wrong. In fact, they got a warrant from a magistrate judge. It was unclear to a magistrate judge. Why isn't this an exemplary case for applying the good faith exception? It's completely unclear to everybody. We may have a view of that in retrospect, but at the time, the FBI agent at issue had no idea that she was doing anything wrong.
Well, first, Your Honor, Agent Fonseca, who was the affiant in this case, has filled out over 100 warrant affidavits, as evidenced on page 2 of the record. She should know, and it's not an unreasonable expectation of law enforcement, that you cannot rely on underlying constitutionally violative evidence to establish probable cause.
Isn't that the issue before us?
Yes, Your Honor.
And you
but
just said
here-
that it's a matter of first impression, but now you are asking us to tell a federal agent, you should have known something that we are disputing right now. That's a part of the debate.
Well, Your Honor, it's unreasonable to expect that she should have at the very least known that a Fourth Amendment violation, a warrantless search, cannot yield admissible evidence. That's a simple fact that all law enforcement should be expected to know. And in Davis, this court allowed binding appellate precedent to apply the good faith exception to law enforcement. But again, this was a case of first impression. So up until that point, that Magistrate Medellin issued that search warrant to the FBI, they included in bad faith that underlying unconstitutionally obtained evidence from Officer Scott. And upon the issuance of that warrant, all they had at that point was magisterial precedent. They were still operating in uncharted territories here. So again, the baseline expectation for law enforcement is to rely on the basic constitutional provisions afforded all criminal defendants.
I've always understood that the lack of clarity, significant lack of clarity, was exactly the basis for the Leon good faith exception, where if there's no clear line that tells you that it's a constitutional violation, then you may have the benefit of that exception.
Respectfully, Your Honor, I would disagree. In Leon, the court squarely sought to address magisterial error, that is a neutral judicial actor's determination of probable cause that is ultimately invalidated. However, Leon court never envisioned an opportunity to give recourse when law enforcement, as the 14th Circuit noted here, it was the constable who blundered and created that constitutional error in proceedings below. That's exactly the case before you. An officer, yes, unaffiliated with the FBI, committed a constitutional violation, and another agency sought to introduce that evidence to a neutral magistrate or judge who, in that agency, should have known plainly that a Fourth Amendment violation occurred. I'd also like to address Petitioner's characterization of the tap and trace warrant here, which is 18 U.S.C. 3127's answer to a pen register, because it allows the viewing of to and from email addresses, likening to phone numbers. But here, Officer Scott not only went beyond the scope of his unequivocal warrant and believed, based on his own judgment, assuming that the FBI had obtained a tap and trace warrant, which they had not, and then took a leap to allow himself to view the subject line, which is content. And 3127 is clear. Content is not viewable by law enforcement during the execution of a tap and trace warrant. To that end, Your Honors, especially in the digital age, in the face of ever-evolving data, this court noted in Riley versus United States, digital media is the privacy of life. The Fourth Amendment protections.
Counsel, if the to from is not content, but the subject line is, then can't we at least admit the evidence that it was from Pestex?
Your Honor, the record's silent here on page 7 as to whether or not that email address said from pestex@pestex.com. And so it's unclear here whether, even if excising that subject line content, the FBI would have established probable cause necessary to do a broad fishing expedition of Respondent's computer the way that they did. But what's more important, and the focus of the court should hinge upon, the Fourth Amendment protections and the privacy concerns here. Officer Scott went well beyond and made unreasonable, reckless judgment during the execution and search of Respondent's computer. Here, Respondent is the sitting governor of a state. So while his warrant allowed him to view files made on or before June 1st, 2014, he went 127 days beyond that, finding an email from Pestex on October 10th, 2014. Think of all the confidential information that was put at risk when Officer Scott made his own determinations, subjective determinations of what the law allowed him lawfully to do. Law enforcement here would clearly be deterred by the suppression of this evidence, not only at the state and federal level, but at all levels. Because here, the suppression of evidence sends a clear message that Fourth Amendment protections, especially in the digital age, facing ever-evolving media, need to stay in place to ensure that law enforcement conduct themselves in the way that this court has allowed. The Leon exception is a narrow exception that serves as recourse for judicial error, not for law enforcement error. The conversation today about Magistrate Medellina's issuance of that warrant still hinges upon the underlying conduct of the FBI. That is the inclusion of that tainted evidence. The affidavit they submitted to obtain that warrant is 1/3 a detailed account of Officer Scott's warrantless search of Respondent's computer. No other facts in that warrant would have allowed them to view and broadly fish for all of the electronic media that they took from Respondent after that warrant was issued. Today, this court has an opportunity to address whether or not good faith truly applies to underlying law enforcement misconduct. We ask that this court follow the lead of the 1st, 4th, 7th, 9th, and 11th circuits, which have adopted as the Ninth Circuit noted in United States versus Vassie, that an underlying taint from an unconstitutional search cannot be cleansed by a magistrate's blessing. A bright-line rule here is appropriate to ensure that the protections of the Fourth Amendment are upheld and that all criminal defendants are afforded their basic Fourth Amendment rights. For these reasons, we ask that you affirm. Thank you.
Thank you.
Thank you, counsel.
Good afternoon, Your Honors. Mr. Chief Justice, and may it please the Court. My name is Jessica DeBeery, co-counsel for Respondent, Governor Paul Rutherford. I will be discussing why the 14th Circuit properly excluded Mr. Smith's statement and Dr. Chin's testimony. When an individual's freedom is at stake, a court should not risk admitting unreliable evidence. Accordingly, Respondent respectfully requests that this Court affirm the ruling of the 14th Circuit for the following two reasons. First, congressional intent and the weight of judicial authority.
Before you get to congressional intent, if you look at the very plain terms of 8033, it seems to clearly and explicitly allow precisely the statement that was admitted here.
Not quite, Your Honor. Looking at 803 subsection 3 in light of the Hillman Doctrine, the way that petitioner seeks to use the Hillman Doctrine would expand the scope of that doctrine. In Hillman, the issue is whether an individual had traveled from point A to point B, and the court used a statement of his intent to do so as evidence that he subsequently did travel from point A to point B. But here, petitioner seeks to use Mr. Smith's statement that he intended to have dinner at Governor Rutherford's house, not only as evidence that Victor Smith traveled from point A to point B, but also that Governor Rutherford at point B invited Victor Smith into his home.
Well, what part of the rule of evidence, 8033, prohibits that? What specific language in the rule prohibits the government from asking the jury to make that inference?
The language in the rule itself, Your Honor, states that a statement of a declarant's then-existing state of mind can be used as evidence of intent, motive, or plan. But it doesn't state that that statement can be used for a third party. And the underlying reason for that
And it doesn't state that it can't be used for a third party, is my point.
It doesn't, Your Honor. However, all of the federal rules are analyzed in light of the reliability of the evidence admitted. And here, the rationale behind the rule is the fact that when you look at an individual's current state of mind, the underlying assumption is that it's inherently reliable because at a current time, a person doesn't have a reason to lie about their own personal intent.
Is it your position that the Hillman Doctrine doesn't permit this?
Yes, Your Honor. It doesn't permit Mr. Smith's statement to be used to his intent to have dinner with Governor Rutherford. It doesn't allow his intent to be imputed to Governor Rutherford's intent or conduct.
Okay, so why can't it be admitted for what it does prove? That is, that Mr. Smith intended to go to the governor's house. Why can't it be admitted for that purpose? His fiancée gets on the stand, she says, he told me he was going to the governor's house. Now, you're free to argue it doesn't prove he ever got there, or that he got there, knocked on the door, and the governor wasn't there, so he went someplace else.
Because, Your Honor, it doesn't have the requisite indicia of reliability to even go before a jury. It's far more prejudicial.
But isn't that the answer from my colleague's question about 803? That 803 does allow this to be admitted. All right, I understand you don't want us to take from that fact that he actually had dinner with the governor. But why can't it be admitted for what it does prove, that he had the intent of going to the governor's house? And then you get to come back and say, there's no corroborating evidence. The government has failed its burden of proof. It didn't show that he ever got to the governor's house.
Because, Your Honor, on its face, the statement by itself does not have the requisite level of reliability to go before a jury and have a jury hear that Governor Rutherford subsequently hosted Victor Smith.
So reliability is a very low threshold, and usually we accept the fact that an entire committee has reviewed the reliability of various categories of statements in determining that it should be a hearsay exception. So what's particularly unreliable about the fact that I say I intend to have dinner with someone? And again, as Chief Justice Bybee indicated. That could be rebutted, but at least it can be, why can't it be admitted into evidence and the subject of dispute or debate thereafter?
Because, Your Honor, any evidence that's admitted in a trial under the federal rules needs to be more probative than prejudicial. And here, this would be far more prejudicial than probative, and then added to that.
But you are
there
not
is the-
making a relevance, or you're not making a balancing, that sort of a balancing argument. You're asking us to read 8033 in a particular way.
Not quite, Your Honor, because as this court has already noted, if Victor Smith had made the statement saying that he intended to have dinner at El Pollo Loco, for example, then that would be fine, because that could be evidence that he subsequently did have dinner at El Pollo Loco. But what's not permitted under the Hillman Doctrine is to say that he intended to have dinner at El Pollo Loco and then meet his best friend, Governor Rutherford, because that would impute his intent on someone else. And there's no way to know what Governor Rutherford's state of mind was and to know that it lined up with Victor Smith's state of mind.
But that's my question. If he says to his fiancee, I'm going to El Pollo Loco and I'm meeting the governor there, why can't we admit the evidence for the fact that that's where he was on his way to, because that's what that he followed up on what he intended to do? It doesn't say anything about Rutherford, and now you and the government get to argue about whether the government has proven that Rutherford also came to the restaurant.
Because at that point, the statement has already gone before a jury, and once the jury has heard the statement, you can't unring that bell. You're placing Governor Rutherford at the scene of a crime, which, when the statement isn't reliable, that simply runs afoul of the
How is it
federal
any
rules.
more unreliable than anybody's statement of intent? Isn't this squarely what 8033 allows?
No, Your
Statement
Honor.
of existing state of mind? I just don't see anything, nothing you've told me makes me think we should restrict this in the way you're suggesting. You can argue all you want to the jury that he didn't go, other things were going on that day, Rutherford had something else to do, but how is a jury not entitled to hear that that's what Smith said to the fiancée about his plan?
Because it's simply unreliable, Your Honor. But if this court is not convinced that the Hillman Doctrine should be constrained in this way, it should at least follow the Second and Fourth Circuits and require independent corroborating evidence.
But
which-
nothing in the plain language of the rule requires that.
It doesn't, Your Honor. However, it would buttress the reliability factor of the statement. And again, here, this statement is simply unreliable. The Victor Smith's statement that he was going to have dinner with Governor Rutherford, it hasn't been corroborated by anyone. And so we're basically allowing this to go in front of a jury and to taint the jury in that way without any sort of proof that the dinner actually occurred.
And you can argue unreliability, and you can argue all the other reasons the jury shouldn't accept that that's in fact what happened.
That's true, Your Honor. However, again, even admitting the statement at all would grossly expand the scope of the Hillman Doctrine based on the holding in Hillman. In Hillman, that only had to, the main crux of that analysis is whether hearsay evidence could be used to show that the man in that case, Mr. Walters, went from point A to point B. Whether Hillman was with him wasn't the crucial part of the analysis. But here, Governor Rutherford's presence with Victor Smith on the night of his death, that's basically handing the prosecution evidence that's based on an unreliable
But
statement.
let's take out the unreliable statement. Look, evidence in a criminal trial is always going to be prejudicial to the defendant. So that's just part of the trial. But what I'm trying to understand is, when you say that it's, you are suggesting that we view this statement and statements like it that reflect or shed light on someone's state of mind as categorically unreliable, whenever they are or may be used to argue about someone else's conduct. Is that the rule that you want us to
Yes, Your
impose?
Honor. Yes, because based on someone else's intent to do anything, you can't impute that to somebody else's conduct. That simply isn't reliable.
But you're also asking us to have a rule where the government could not argue, to pick up on the questions of my colleagues, could never argue about someone else's conduct, what someone else did, based on a declarant's statement.
It could, Your Honor, but this court should require independent corroborating evidence in that case to enhance the reliability of the statement, as the Second Circuit does, as it did in United States versus Best. As the Second Circuit noted in United States versus Kaplan, a great danger exists in admitting hearsay statements to prove the conduct of a third party. And in that case, a DEA agent used a statement of a decedent to attempt to prove that a defendant was involved in a drug distribution ring. And while the trial court did offer a limiting instruction to the jury, the Second Circuit held that that jury instruction wasn't sufficient because there was too much risk that the jury would still misuse the information and regard it inappropriately. And so the Second Circuit reversed. And similarly here, allowing the statement of Mr.
I thought that we affirmed, I thought the Second Circuit affirmed in Best.
Sorry, not in Best and Kaplan, Your Honor.
Oh, okay.
In United States versus Best, to move on with that, United States versus Best, the Second Circuit stated that independent corroborating evidence could come in the form of the subsequent conduct of a non-declarant. And so in that case, a man was accused of being involved in a Medicare scam. And the court there held that because there was subsequent conduct of the non-declarant that indicated that he actually did participate in the Medicare scam, that was sufficient to buttress the reliability of the statement, and it was admitted into evidence. But here, there isn't any sort of independent corroborating evidence.
Well, I
No
come
one
back
saw.
to the same thing. There's nothing in the rule that suggests that corroborating evidence is necessary, and you can always argue to the jury, reject this statement because there's no corroboration.
We could, Your Honor. However, to go to the issue of congressional intent, this court can look to the report on the House Judiciary Committee and construe any ambiguity in the rule in accordance with congressional intent. The report on the House Judiciary Committee at the time the rule was passed indicated that it was to limit the Hillman doctrine.
That's one member of the House. How do we know what anybody else thought? What do we know? We don't know about what any senators were thinking.
We don't, Your Honor, but we do know that the representative that was in charge of the committee.
It's a real danger in using legislative history in that way, because the committee thought it was for a different purpose, wasn't it?
I'm sorry?
Because we have an advisory committee that thought that the rule was adopted for a different reason. So now we're trying to figure out motivations for passing a rule that we can read.
That may be true, Your Honor. However, the advisory committee isn't composed of congressmen. It's not composed of elected officials who actually pass the rules.
But the best that you've got on the other side is one representative.
We have the entire committee, Your Honor. There is a report that was written by that committee, and that was what indicated that the rule should be limited just to the conduct of the declarant. So looking at the congressional intent here, it is clear that Congress did intend to
If we
limit the
adopt
rule.
your preferred interpretation of 8033 and limit it to the intent of the declarant, then why don't we admit what Mr. Smith was going to do?
I'm sorry, could you repeat
Then why
the
don't we
question?
admit the statement, his fiancee's statement, for the purpose of admitting what Mr. Smith intended to do?
That would be appropriate, but so long as Governor Rutherford isn't mentioned in regard to that statement.
Well, but Mr. Smith said he intended to go to the governor. He intended to have dinner with the governor.
Again, Respondent does contend that it's not reliable enough, but with my remaining time, I'd like to move on to Dr. Chin's testimony. Here, based on this court's holding in Crawford versus Washington, as well as Melendez-Diaz versus Massachusetts and Bullcoming versus New Mexico, it's clear here that the autopsy report is testimonial. It was formal as conceded by the government on page 33 of the record. And based on the Board of State autopsy law and the enumerated reasons why an autopsy might be performed under the Board of State autopsy law, it was foreseeable that in this case the autopsy report would be used in future prosecution. And given the fact that
Let me just ask you something. I have to go back to what your colleague, your opponent said at the end of her argument. Doesn't this effectively, your position effectively impose a statute of limitations on murder?
No, Your Honor.
Why?
Because for example, looking at the Board of State autopsy law, Dr. Fleischer had the option of audio and video recording the autopsy report in this case, and he chose not to do so. So in a case where
So
that did occur.
every autopsy report should have its author, they should video the author? And 20 years later, when a cold case is solved, that's going to be admitted?
That would be a way for someone like Dr. Chin to offer surrogate testimony. But here, Dr. Fleischer's subjective sensory observations of the condition of Victor Smith's body cannot be admitted by some backdoor by allowing Dr. Chin to testify as to something that she was not, and she did not observe
What if you
actually.
redacted the reference to the odor and so on, all the things that I think you would describe as subjective? would that be enough? Would that satisfy you?
It would not be sufficient, Your Honor, because the conclusions that Dr. Chin came up with by looking at the autopsy report are inextricably tied to Dr. Fleischer's subjective observations. And so in that way, she wouldn't be able to, we still wouldn't be able
So
to.
you're saying even if she said, I do not rely as an expert on his subjective observations about the odor and so on, that would not satisfy you?
If she didn't rely on the contents of the autopsy report, that would satisfy.
No, not on the context. The contents that I take it you find objectionable are the more or less subjective contents.
Yes, Your Honor. But, and if those weren't relied upon, it would beg the question of what she would actually be looking at, because Dr. Fleischer's conclusions as to the cause of death were largely based on his sensory observations of Victor Smith's body at the time he performed the autopsy. And
But
so,
sometimes what's relied on is just pure data that isn't subjective at all. That's just data. You know, a reading of alcohol content in blood or something that's just pure data and in no way based on an opinion. What's your position on that?
Your Honor, I see my time has elapsed. May I answer your question?
Yes, please.
It is true that in some cases that it is data. For example, in Melendez-Diaz, in Bull Cumming, that was a blood alcohol test. But even there, this court held that it was subject to the confrontation clause because the analysts that perform these tests are human, and they should be put through the crucible of cross-examination to prove that they have been proficient and honest and capable.
How many of them do we have to put through the crucible? I mean, arguably in a trial, there might be 10 people in a chain of testing that you'd have to call to the trial?
No, Your
To the
Honor.
hearing?
No, Your Honor. Only those who were necessarily involved in preparing a final report here, such as an autopsy, the autopsy report at issue here. You wouldn't necessarily have to involve every single person, but when it comes to something like this where there are subjective observations being made and the only individual that can testify as to his procedures involving those observations is the medical examiner, then in that case, the medical examiner's presence should be required. Thank you, Your Honors.
Thank you, counsel. Petitioners have some time remaining.
Thank you, Chief Justice, and may it please the court. On rebuttal, I'd like to address just a few quick points. First, with respect to Rule 8033 in the Hillman Doctrine, opposing counsel misrepresented the facts of Hillman. In Hillman, Walters, his letters were used to show that Hillman, a third party, had in fact traveled from point A to point B and could not have been the body discovered in that case, and thus the beneficiary of the life insurance policy could not collect on that policy. And furthermore, 8033's plain language does establish that this type of statement can be used, and the best indicator of congressional intent is the plain language of the statute. Simply because one member or even one committee of the House decided that this should be limited in a certain way, if the House intended to limit it in such a way, they could have altered the language of the rule in order to make it something that the entire body of Congress could vote on. Allowing congressional intent to be determined from a simple committee report would violate the constitutional requirements of bicameralism and presentment. With respect to the Fourth Amendment issue, Your Honors, opposing counsel charges Agent Fonseca with knowing what this court's decision will be in a case of first impression before this court even knows what its decision will be. Furthermore, the lower court's decision in the 14th Circuit was also a case of first impression, and the other circuit courts have split on whether the underlying tainted information can be sanitized by presenting that information to a neutral magistrate and allowing
So
that
maybe the
magistrate-
point is, Agent Fonseca, okay, you get your evidence in this case, but going forward, everybody should know that you cannot use evidence that was obtained illegally by state officers.
Your Honor, if this court did decide to say
She
that...
may win this case, but she may not win the next case.
Your Honor, the touchstone is whether officers objectively reasonably relied on a warrant. And in this case, because there was no reason for Agent Fonseca to believe that she was not objectively reasonably relying on that warrant, then the good faith doctrine should apply. And when officers act objectively reasonably, there will be no deterrent value to excluding or suppressing evidence that is obtained in such circumstances. And for those reasons, Your Honors, we respectfully ask this court to reverse the decision below. Thank you.
Thank you.
Thank you.
The case of United States of America versus Paul Rutherford is submitted. The court will take a brief recess.
Sorry.
Is this working? Hi, my name is Katerina Garced. I am the coordinator of this year's Prince competition. While the judges deliberate, we will be giving individual awards for third best brief, second best brief, and best advocate in the preliminary rounds. And before I do that, I would just like to say thank you to everyone for being here. From what I have heard from the professors and the people that we have scoring the briefs, and from what I have heard from the judges of the preliminary rounds and throughout the whole competition, your performances have been absolutely excellent. Thank you for the finalists for being here, and to all of the teams here. And we will now be announcing those awards. With third best brief, Team 19, Southern Methodist University Dedman School of Law. If you are present, please step down to receive your award. Well, with second best brief, Team 32, University of Florida Levin College of Law. And with best brief, Team 5, Southwestern School of Law. And now, with Best Oralist in the preliminary rounds, Tyler Summers from Team 19, Southern Methodist University Dedman School of Law. Now it will be a few minutes while the judges deliberate. If everybody could please hang out, and when they return, they'll be giving their remarks. And again, thank you so much for being here.
Please be seated. I was a law student many years ago. I have attended a number of moot courts, both in my capacity as a law student and later as a lawyer, and now as a judge. And at this point, the presiding judge is responsible for giving the following speech. And the speech consists of several elements, and it's sort of trite. It's a canned speech. I'm going to explain in just a minute. But the speech is to tell you how good the competition was, to tell you that as judges we wish that the quality of oral advocacy was as good before our court as we have seen today. Now, there's a reason why we give that speech every time. It's because the speech is true. The quality of oral advocacy at this level is, on the whole, better than the oral advocacy that we see on a day-to-day basis in our courts. Part of that has to do with the fact that you've had a little more time to think about this. You don't have the pressure of private practice. You've been well honed You've been tried in the refiner's fire both at your schools and then when you came here and worked your way through the competition. But let's just say that this was a terrific final round. I also want to say something that I said before we came out on the bench the first time, and I said this to several of our hosts from Brooklyn Law School and I thank them very much for the invitation. I thought this was a very, very well-written problem. I have judged a number of moot court problems. Writing them is a little bit of a trick. Sometimes there are corners that you haven't seen, that you couldn't have anticipated. I thought this problem was very, very well written, and I thought the materials were excellent. I hope that you appreciated the problem. And I thought that that it was a very equally balanced problem. It was very nice when you find circuit splits and have circuits who have articulated contrasting reasons. In terms of our overall comments about the oral advocacy, again, I want to repeat how good and how solid the advocates were. To both teams, we don't know where you're from. We'll ask you in a few minutes where you're from, and you can tell us. But you're welcome in my court any time. And I come from a cool court. We have lots of really great cities out on the Ninth Circuit, so you got to think about it.
My court is a lot closer, so come to it first.
Just as some general comments, and these are not directed at anything that these advocates say, but I just want to say that these are the kinds of things that when I get asked questions about lawyers, about my pet peeves in oral argument, these are my pet peeves. And I'm not sure that these were applicable today, but I just want to pass these along for the benefit of all of you. Okay? Number one, answer the questions as directly as possible. If the judge has asked you a question that you think the judge thinks can be answered with a yes or no, try to answer it yes or no, and then explain yourself. If you try to tell the judge what a stupid question it was, the judge isn't going to understand your answer, and he or she is not going to appreciate it anyway. So try and answer it and then explain it. In my court, if you don't answer a question sort of yes or no, you will get one of my colleagues who will do one of the following. They'll say, "Counsel, I asked you a yes or no question. Yes or no." And that's not a good position to be found in. Even worse is with one of my colleagues who will ask you about twice, and on the third time he'll say, "Okay, well, if you don't want to answer the question, I'll just assume that the answer isn't good." Again, not a good position to find yourself in. Number two, probably as a general comment, know the record and represent it fairly. One of my biggest pet peeve has to do with candor from the lawyers. You're not responsible for your client's bad case. Your client probably brought the bad case to you and the bad facts. You are responsible for being completely honest with the court. And if you've got bad facts, drive through them. You're going to have to confront them because I've got really, really smart law clerks who are going to help me figure all of this out in the end. And you're not pulling anything over on me by trying to elide important facts. If there are bad facts in the record, drive through them, explain to me why they're significant, why your client still wins. So those are just some general observations from the bench, and I will allow my colleagues now to offer their comments.
I'll step in. So I thought, just to echo what Chief Justice Bybee said, you were all great. You listened very carefully to the questions that were posed, and you answered them. You answered them in a straightforward way, and there were a lot of questions coming from different perspectives. But this ability to listen very carefully to the questions, I agree with Judge Bybee, is the most important part of oral argument. Now, you also, I think, all understood that you're engaged in a conversation. So there's a back and forth, and it's not a one-way street. And I thought all of you did that very effectively, sort of engage us in a conversation about these very thorny issues for the most part, I thought. I want to commend, while I'm on that train of thought, the folks who wrote the problem. I agree that it was a well-balanced problem and also very well written. Certainly made my life easier. A couple of other observations. You all knew the record. There was some dispute about what the record was. It was not a very big record, but you all knew the record very well, and you were able to turn to the record when it helped you, or explain the record when it didn't particularly help you, and I very much appreciated that. And I thought, just to pick up on something that Judge Bybee said, that you were straightforward when it came to identifying or acknowledging at some level the weaknesses in your case, because that enhances your credibility when you're up at that podium, and that's very important, not only for the particular case, but for the next case when you appear before a court. People will remember that, believe it or not. And finally, you seemed like you were actually having a little fun and appreciating the fact that you're in this oral argument and engage in these difficult issues. That Crawford issue in particular is a hard one. And I thought you all did a great job. And you seemed also, for people who are just in law school, to be very much at ease at that podium. And that says a lot about you. You should feel confident that once you get out of law school, you'll be at the very tippity top of oral advocates if you keep this up in the profession. So I commend you, and thank you again for the law school for giving us all this opportunity.
I echo my colleagues' comments completely. What struck me about every one of the four of you was, and it's sort of what Judge Lohier just said, how comfortable you were arguing. And we threw questions at you. We threw, you could have been off your game. You could have been really thrown off, where you were going, but you weren't. And you were really, I thought, particularly effective at coming back to answering our question and then very eloquently getting back to where you wanted to be. And then you have him sitting there putting the time thing up, and yet not one of you really got off your game. You all wrapped it up in a way that was just seamless. So it never seemed like, oh my goodness, I only have 1 minute. You completed your thoughts every time. I thought your knowledge of the record was tremendous, and I thought your ability to handle our tough questions was really impressive for law students. And I thought that all of you were really still who you are. Your personalities came across. And I think that's something that you should try to do as you go forward in your life as oral advocates. And I congratulate you for it. Good job.
If you're interested, I will tell you about our discussion about the merits. So if this panel were responsible for deciding the case, it would probably be affirmed in part and reversed in part. As to the exclusionary question, the panel was inclined to exclude the evidence on the basis of the warrant. On the basis of the 803 evidence, this is the evidence from the fiancé, we were inclined to allow that in, so we'd be reversing the 14th Circuit on that question. On the Melendez, Bullcoming, Crawford, Williams mess, the answer is we will do whatever Justice Gorsuch tells us to do.
We really don't know.
We have no clue what to do on that one. So if you're sort of judging this thing on the merits, it is a complete toss-up. One side wins one side wins the other, and the other one it's a you pick 'em. So we don't know on the merits. All right, Glenn, am I responsible for? Okay. It is our solemn duty to declare a winner today, and in a very close vote, but a unanimous decision by the panel. The winner of this year's Prince competition is the Petitioner, team number 17.
Where are you all from?
Ohio State.
Ohio State.
Wow.
Buckeyes.
Buckeyes.
The
Ohio State.
The Ohio State.
When you get confused with some other Ohio State.
Is this working? Our runner-up team, Team 2, from University of California, Hastings School of Law. Congratulations. Dean Allard, if you would like to please step forward and say a few words, we would love to have you.
Well, congratulations. I was really focused, I was mesmerized until the conversation turned to Kentucky Fried Chicken. My mind started wandering to Junior's, the Queen, the River Cafe, even your banquet menu tonight, so I hope you enjoy it. So, like the Academy Awards, there could have been multiple winners. But there is one winner tonight. But congratulations to all of you. So impressive, as you heard from our panel. And what a distinguished panel. I mean, just incredible. And the fact that these leading jurists have spent so much time obviously preparing Knew the Record inside out, and gave you the great courtesy and the gift of treating you as the professionals that you already are, as all of you other contestants on the other 30 teams, 30 plus 2 equals 32, by all the judges. I sat in on some of them, and I was impressed incredibly not only by the quality of all of you contestants, but also the work of all the judges who were volunteering. It was quite remarkable. So let's give this distinguished panel a huge round of applause. I think you know them, but let me start as I'm most comfortable on the left doing, and I'll just, for those who might not know, Judge Azraq is a judge who is well known to us here in New York and Brooklyn, and since Brooklyn is the center of the universe, that really counts for a lot. And she is United States District Court judge for the Eastern District of New York, which has just recently celebrated its 150th anniversary or two ago, and it's a very, very historic venue. She, like the other two judges, has something in common which is very significant United States Justice Department experience. So keep that in mind when you're thinking about your careers. It sounds like it's a great launching pad and incredible experience. But she started in the civil division. Criminal division, see, I got that right? I can get that at home, you know, correcting, it's okay. And was an assistant United States attorney. I got this all screwed up here, but I do know this. She's well known. Right?
For something.
United States Justice Department's really criminal division? Mm-hmm. Wikipedia says civil division. You can't trust everything.
There you go.
Okay, so criminal division. But she served leadership positions, including the deputy chief of the narcotic section, and then the deputy chief of the criminal division, and finally the chief of the Business and Securities Fraud section, so I hope I got some of that right. I do know that she served very ably 14 years as the United States Magistrate Judge in the Eastern District, and many of those years was the Chief Magistrate Judge, and then was appointed by President Obama to the Eastern District of New York, and is serving to this day on that bench, and we're very grateful for her service. Our Chief Justice today comes to us from Jay Bybee from the Ninth Circuit, as you heard, and he's a United States Circuit Judge from the Ninth Circuit. He started in private practice, but then began in the Justice Department with the Office of Legal Policy, then the Civil Division in the Justice Department, and had an incredible experience working with President George W.H. Bush, or is it H.W. Bush? H.W. Bush, as his assistant counsel in the White House. He has worked for a long time. He did work for a long time as a law professor at two great universities, LSU and UNLV, and then served as Assistant Attorney General in the Office of Legal Counsel. The Office of Legal Counsel, as most of you know, is really the sort of the cop for the other lawyers in the administration, and it's a very, very sophisticated position. And from there, he was appointed by George W. Bush to the bench, was confirmed, and has been serving for quite some time. He's the author of 2 books on the Constitution, and a couple of dozen top law review articles, and we're very, very grateful that he and his wife came here and joined us from the Ninth Circuit to be with us for this program. Judge Raymond Loyer is, as you know, United States Judge on the Court of Appeals for the Second Circuit. He also started in private practice, became an assistant United States attorney, and led the task force on securities and fraud. I think he may be known pretty well for investigative work on the Madoff scandals and failings. And then President Barack Obama named him to fill the vacancy created by Justice Sonia Sotomayor's elevation to the Supreme Court. And so he's been serving in that capacity since. We're very glad to have him. We're glad to have all 3 of these distinguished jurists with him. And then let's give them another round of applause for the work they've done. So just a few words. If you wonder why all of the folks, all of the people who served as judges have worked so hard and made their time available to you, and also why your various coaches and teachers who have been with you have put so much effort into this exercise, it's probably for a simple reason, and that is that what we do in law schools and what is involved in creating good new lawyers matters. It makes a difference. Now, you all are already accomplished. You're on your way. But the work you're about to do in the private and public mission that all lawyers perform is really important. You are those who are going to be the architects of economic opportunity. You're going to be the champions of those who need to be defended or represented. You're going to be the builders of bridges over chasms of disputes that are often seem too deep to bridge, and you're peacemakers at home and abroad. All of those things, but also what your very important mission will be is to educate others. And there's 2 parts to that. First, as the Second Circuit is engaged, I know the Ninth Circuit is engaged, I think all the circuits are engaged, the mission for lawyers to engage in civic public education about our justice system is incredibly important. And so when you go out as lawyers, it's going to be very important by conducting your work in such an incredibly impressive way to educate others about the importance of the rule of law and how it operates, but also in taking the time to teach people about the rule book, the Constitution, about engaging in dispute resolution in a civil way according to a rule book. And so that mission of civic public education is incredibly important. Second, it's really important for our system of government to be legitimate, for all of you to succeed, but keep this in mind. It's really important that lawyers and the people they represent the full range of people in our country and around the world. I hope some of you have gotten a chance to see Brooklyn and New York City in this short visit here. If you were to ride on the 4 train, it starts in Woodlawn in the Bronx. Then it goes through the Upper East Side, it goes down to City Hall, Brooklyn Heights, where we are, Wall Street before Brooklyn Heights, and then it ends up in Crown Heights. If you were riding, you'd see the hands of the people on the poles and on the ropes, and those hands are all colors, brown, white, black, the full rainbow. And they're the hands of people who are wealthy, and they're hands of people that are less advantaged. And they are the hands of people who, many of them, can be good lawyers, and also the hands of people who need lawyers, whether they're rich or poor. And so it's really important that you, as you go out, and I'm saying this because you're all going to be extremely successful lawyers, that you make the effort to help other lawyers become great lawyers, and that you make sure, to the extent we can, and it's never going to be perfect, that effective, high-quality legal services are available to all who need them because it makes such a big difference. Okay, so not a sermon, just a few thoughts. An event like this does not happen by accident. It took an enormous amount of preparation by all of you, as the Chief Justice said, and that was evident in all of your preparation. I'm enormously proud of the work that our law school students and the faculty have done and the judges have done, and we're very, very grateful to all of them. I'm sure that Glenn and Katrina are going to be thanking everybody on the e-board and the writers and all that. I do want to give a shout out to our faculty advisors. We've always had fantastic faculty advisors, from Ursula Bentley, Neil Cohen, Molly Falk, who? Well, Robert Pittler, the late, great Robert Pittler. This was a very special event for him, and we miss him. And then, we have the current faculty advisors, and Cameron Arnold, Professor Cameron Arnold has done a tremendous job, and Magistrate Judge Stephen Gold has done a phenomenal job as usual. And of course, the big kahuna, the Uber advisor, is the Associate Dean for Practical Education, who is also the advisor in her spare time for the Moot Court Honor Society, Stacy Caplow, Professor Stacy Caplow. So thank you all for that. So the Moot Court Honor Society here is such an important part of their education. It's not an add-on, and I'm enormously proud. This year, for example, now I know Hastings always does well, and OSU, you know how to dot the I, right? So you're always doing well in these kind of competitions. But this year, our Moot Court Honor Society had 11 teams that advanced to the semifinals or better, and 2 best brief victories, and they keep going on and on. And as I said when we opened this a few days ago, they're costing me a fortune because I got to pay for them. They keep winning, going to Vienna, they're going to Oxford and around the country. So please have your deans have to bear some of the expense. Thank you very much. I'm going to hand this over to our student leadership.
Hi again, everyone. So earlier, we presented the awards for third best, second best, and best briefs. And we also presented the award for, or we announced the award for best oralist in the preliminary rounds. However, we noticed that some teams have joined us since, so we are going to announce them again. With third best brief, Team 19, Southern Methodist University, Dedman School of Law. If you are here, please step forward to receive your award. With second best brief, Team 32, University of Florida, Levin College of Law. And with the best brief, if you could please stand when we call your name, Team 5, Southwestern School of Law. Congratulations. We also have an award for the best oralist in the final round, and that award goes to Lydia Bolander from Team 17, Ohio State. Congratulations to all of the teams for your performances this weekend. All of the judges these past few days have had nothing but wonderful things to say about your arguments and have been thoroughly impressed by the quality of your performances. In fact, several judges have remarked that in their many years of judging the Prince competition, this year's competitors have been the best that they have ever seen. We are honored to have hosted 32 amazing teams for this 32nd anniversary year. I just wanted to say a few quick thank yous to those who have been integral to the Prince competition's success. Judge Jay Bybee, Judge Raymond Lohier, and Judge Joan Azraq, we are honored to have had you preside over our final round. Thank you for volunteering your time to be here with us. We truly appreciate it. And we have some gifts for you as well. Thank you, Dean Allard, for your continued support of the Prince competition. If you could please come up, we have something for you. Thank you to our moot court faculty and writing team advisors, Dean Stacy Kaplow, Judge Stephen Gold, and Professor Cameron Arnold. You have dedicated so much time and attention to helping the Prince competition this year and every year, and I could not have done this without you. Professor Arnold, you have been wonderful these past few months, especially in the weeks and days leading up to the competition and throughout, and your support has been invaluable. If the three of you could please come up, we have something for you. Thank you. Yes. Also critical to this competition are our Prince problem writers. If you could please come up when I call your name. Megan Boland, J.C. Gottlieb, Kristen Hackett, Amanda Martin, and Eliana Openshaw. Unfortunately, Megan wasn't able to make it for the final round, but I would like to thank you 5 all so much for your hard work. You have spent so much time and effort throughout this past year to create this incredible problem, which has received unanimous praise from judges and competitors alike. Without you, we wouldn't have anything to compete about. So we truly appreciate all of your work. Prince could not happen without the help of Beth Palastro and Joanne Tapia. I cannot thank them enough. I don't think Joanne is able to be here today, but Beth, if you could please come up, we have something for you. I just realized that I forgot to announce the best oralist for the preliminary rounds for a second time. So sorry about that. Best oralist for the preliminary rounds, Tyler Summers from Team 19, Southern Methodist University, Dedman School of Law. Congratulations. Another 2 individuals that I would like to thank are Chris Gibbons and Mike Licari. These 2 were absolutely essential in making sure that this competition came to life, and they handled each of my frantic phone calls with a quick solution and constant encouragement. So thank you. I also want to thank my amazing Prince committee. All of them have put so much effort into their roles, from decorations to scoring and everywhere in between. And many of them have actually been here for over 32 hours over the course of the last 3 days, which is a huge time to dedicate to anything, especially when you're a law student. This competition could not have happened without you. In particular, I would like to thank Michael Conti, because I don't think that there is a single aspect of preparing for this competition that he didn't help me with, from making copies to emotional support to feeding me. So thank you. I also owe a huge thank you to the other members of the Moot Court Honor Society Executive Board. I am truly floored by how supportive they have all been leading up to the competition, and especially throughout. They have been here working with me all weekend to ensure the success of the competition and filling in with whatever task or shift was needed. In particular, I would like to thank our president, Glenn Radecki, who has been such a calming force for me throughout these past 3 days, always by my side, ready to help resolve any issue or do anything that needed to be done. I owe much of the success of this competition to you. Thank you. Finally, I'd like to thank my parents and my friends and family for their constant support, words of wisdom, and encouragement. Thank you all.
The one person that wasn't thanked is our amazing Prince competition coordinator, Katerina Garcet. And I know many of you saw her over the weekend, but the truth is that Katerina's work has extended through the entire school year, from coordinating with the Prince writing team, to organizing the judges, to making sure that you were all fed during all of the rounds, to organizing the banquet and the after party today, to making sure that this competition runs smoothly. It's not hyperbole because it's true. The Prince competition does not happen without Katerina. We are honored that she took so much effort this year, and we are proud to have her as our competition coordinator, and we cannot thank her enough. Thank you.
And that is a wrap. Thank you all for coming.